Clay, did you see that the on the Behind MLM story? And people hate that I share Oz's links, but I think I think he's incredible. And yeah, he's pretty critical, hypercritical, but he does do some great investigative journalism. And but there was recently the Issigenix case. Clay, did you see that, where the court said that if you don't publish the change, if you don't notify the field of the contract change, it's not binding? Somebody had a question about that. Did you see that? If you didn't, I can talk about it. You're muted. You're muted. We can't hear you.
I didn't see all of it, but I'll let you take it over if you want.
Yeah. So distributors got in litigation with the company. Maybe the company sued them and said, hey, you're under a non-compete or non-solicitation. The rep's response was, when we joined, that provision wasn't there. And of course, in the policies that we write, it says that companies can change it from time to time. The reason for that, it's not really nefarious. It's not a nefarious clause in the contract. These companies don't dramatically change the policies. It's just, if the regulatory landscape changes, or if the non-compete law changes, like in California, non-competes are no longer legal. If anything changes, the company needs to have the right to modify their policies to be consistent. So the basis is good for the company having that right to change the deal. But the court said, because the company didn't push out the notification, they didn't notify the field of the change, it's not binding. So the rep was able to have a good outcome. And really, it's not much of a discussion. The point is, for these companies, when you change these policies, give the field 30 days notice. And sadly, it is take it or leave it. But then there's the argument: well, if the rep leaves it, can the company pursue them if they chase another opportunity? Well, sadly, the answer is yes.
It is, but let's look at something here. What is classified notification? And here's where the basis of my question's coming from. Many times we see a pop-up when somebody logs into their back office. And it basically, before you can get your money, before you can do anything, you have to agree to it. And it's a forced issue. The other one that I've seen, and I want to know I want your guys' opinion. You're the legal eagles on this. The other one is, you get a hard check.
30 days notice. And
the check will say you're agreeing. If you cash this, you're agreeing to the policies and procedures. So are either one of those, would that be acceptable in a court of law as, hey, we've notified the reps?
I think the answer is yes. There's been an argument that in contract, there's a thing called contract of adhesion, where it's a take it or leave it change. And that there's an argument that sort of change is not enforceable. And that happens when you don't have an equal bargaining position. So I think reps always have that argument. I don't think the law is really settled on that issue. And so whenever we represent distributors, and we do on occasion, we've got a fantastic labor and employment lawyer, J.K. Sims, and he's doing some distributor cases now. That's the position that he typically takes, is that these contracts are unenforceable because there's no bargaining power, there's no negotiation. Yeah. And before those issues are decided, before it goes the distance and there's an outcome, usually the case is settled.
Sure.
So the answer to your question is, we're still in the gray.
I got you.
On that
one.
Okay.
It all goes back to transparency too. I remember the case now, Kevin, what you're discussing. There's not really you have to do this to make it appropriate, but if you're making a change, why do you need to hide it kind of in page 30 or whatever? Like if you just say we changed section 8 to this, then they know, and they've continued to use their back office, et cetera. And that's kind of the end of it. Of course, when you change the dispute resolution, there's more issues there, but transparency, it's really what it all goes back to, I think, in the industry, is just tell us what you're doing.
Well, and the problem is, though, we've advised companies to push out these notices. They don't want to highlight the fact that they're adding a non-compete.
And so I don't understand that.
Yeah. Because they'll lose people.
Well, but they can't lose people if they got them under a non-compete already.
Yeah.
So, I mean, it's, it goes back to what's first, the chicken or the egg, because you've already got them locked in under a non-compete, which I'm not a fan of, and you know that. But if you've already got them there, then be open with them. Here's the other frustration that I'm seeing from some leaders, because we've been talking about rank and file. Let's look at leaders for a second. They hit a certain rank, and then they get a secondary agreement that comes out that's even stronger than the first agreement, that if you're going to get this bonus, or we're going to promote you on stage, then it's going to even be tighter. I mean, it's still one-sided. There's nothing that reps can't do to say, let's negotiate, bargain, let's do something on these?
They can.
Okay.
Yeah, that's where it's strength in numbers. And so the Amway, they've got basically what I call a labor union, but it's what they call the IBOAI. It's the Independent Business Owners Association International. And so the company has to negotiate with that board, and that board represents the field. A lot of companies aren't mature enough to have that sort of arrangement. They don't want that sort of arrangement. In their opinion, they don't need it, and so they don't do it. But you're right, reps always have bargaining power. What you mentioned there is, as reps climb in rank, companies will ask a separate agreement. That makes the contract more enforceable. So, hey, you're making money. You're not a victim. This isn't something. This is, if you impose a non-compete on every single person, there's an argument that's overly broad and unenforceable. Doesn't make sense to impose a non-compete on somebody who's earning zero income.
Correct. Yeah.
So in some companies you're seeing, and I don't want to name names because some of them are clients, but as people climb in rank, then they say, hey, congratulations, you're now a new emerald. Sign this agreement. Right. And they do it. They sign it. Hey, I want the money.
Well, let's, on that, Kevin, because a lot of times now you're just clicking a button in your back office and saying, yes, I agree. I mean, they'll show the agreement. Don't get me wrong here. Companies are doing it right. But then it's not like it's a real digital signature. It didn't come through DocuSign. You're just agreeing. Hey, yeah, I agree to that. Here's my timestamp. Boom, it's over. Is that enforceable? I mean, if people want to balk at that, is that something the courts have made decisions on? Yes, that's still an electronic signature.
Yeah, that's enforceable. It's called a click wrap, where, deciding to proceed with the relationship is consent.
Okay.
So
well, reps need to know that. Yeah.
Yeah. The reality is they don't have the employment rights that they think they have. And I see a lot of frustration on that issue year after year, where people are saying, distributors, they think they're told they're building their own business, that they own something, when in fact it can be taken from them at any time. And the sad thing is that's true, right? The contract law is pretty clear that they're independent contractors. And as an IC, it's like hiring a painter for your house. You can fire them whenever you want. And that's, whether you like it or not, that's the state of the law. And it goes back to your original, one of your points was reps can negotiate these things if they organize.
Right.
That's tough.
Right.
That's really tough. That's the wrong company that like rules like Adolf Hitler is like, okay, this person's causing problems, off with his head.
Yeah. I've seen that.
Yeah, that's dangerous.
I mean, the designation, and this is something I think that is important in our industry. It was a 1986 tax bill that in the same bill, real estate agents and direct sellers were listed as independent contractors, as statutory non-employees, I think is the term they use. And a lot of times people think independent means I can do whatever I want to do. And they don't even understand that the policies and procedures, terms and conditions are a contract. We don't have enough education for people to even understand what they're pushing at the moment that they join.
Yeah.